This feels like home, nobody listening to me and a lot of noise in the background. So I'm here, and I think I'm the third person to speak to you on the same subject. It's right, I've taken a very generic approach to it. I go, can you hear me? Can you hear me now? I've taken a fairly generic approach to it because, as the last chap said, you have to have a whistle-stop tour on something like this. But it's also the beginning of a piece of legislation. It's the beginning of a new regime. There's quite an amount of information on the internet available. The legislation itself, the appointed date, order, and there are three steps, three items awaited, which will become clearer when I finish speaking. There's the code of practice, which is out in draft. There's the payment claim notice form has been circulated, and there's consultations on that, and that will be finalised, and then we're awaiting the rules of court. Why is it? Well, the purpose of the bill is basically to make sure that contractors, subcontractors and subcontractors are paid on the basis that, following the English model, that cash is the lifeblood of the industry. When? Well, it will commence on the 25th of July. The commencement order was made, and all contracts after the 25th of July will be subject to this new regime. Who is affected? Well, it applies to parties to a construction contract as defined. That is the carrying out, the arranging for the carrying out, the providing one's own or others' labour for construction operations. And construction operations are any activity. So almost everything will be included, from advisory work right through to providing labour to a project. I would imagine this is the area where there will be some challenges in very few instances where people will be saying, well, that doesn't apply to me. Who does it not apply to? Well, it doesn't apply if the value is not more than 10,000 euros, so a very small job, or it's a dwelling, it's only a dwelling which is not greater than 200 square metres, and is to be occupied as a residence of one of the parties. So spec building wouldn't be included in it, say, for example. It doesn't apply to a contract of employment. It doesn't apply to a public-private partnership arrangement, but the state is not excluded. So state and local government are not excluded. They're in except for the PPPs. How does it operate? Well, it operates by, it requires that every contract will have provision for interim payments. It establishes a default mechanism for establishing the point at which the interim claimant is, if you like, determine the payment claim date for work up to a particular date. It then provides a default mechanism to establish when those payments are due. And then it provides a method of clarifying any disputes that may exist between the provider of the service and the person who's paying, and I'll deal with that in a moment. But if a real dispute arises, it provides a statutory adjudication process, which has been in existence in England for a number of years and other jurisdictions. It's new here, we'll talk about that. And then, very importantly, there's a statutory right to suspend work if you're not paid, either on the initial account or on the payment of the adjudicator's decision. In each case, following 7 days' notice. The new statutory requirement for interim payments is that every construction contract, whether written or oral, must provide for interim payments, except for certain very short contracts of 20 or 45 days. The amount or adequate mechanism for calculating the amount due, an adequate mechanism for calculating the payment claim date if you haven't nominated that date in the contract, and then a mechanism for determining when the money is to be paid. If the contract is silent, then the provisions in the schedule apply. So every contract either has this, or if it's silent on it, it's brought in, whether it's written or oral. Pay when paid is no longer allowed, and contracting out is not permitted. So this applies there. The payment claim date requires that a construction contract will have a payment claim date or an adequate mechanism for that. And again, if it's silent, the schedule of the Act applies. Then a payment claim notice is a formula that is a step rather to be taken, and the department has circulated a draft of this payment claim form for consultation. That's not mandatory because the Act doesn't require a particular form, but it's a very good guidance and people will be using it. If the notice must be served not later than 5 days after the payment claim date. If the claim is contested, a reasoned response must be not later than 21 days after the payment claim date. So I claim 10k, you come back and you say no, 6k, but you must give a reasoned response, and the time frame that is within 21 days. And then on the appropriate day, on the due date, you must pay the 6k, and that leaves me paid the lesser amount and a dispute between us as to the balance. But you must pay. If you don't pay the lesser amount that you've said in your reasoned response is due, so I've claimed 10,000, I've itemised it, you say no, it's only 6,000, you give reasons why it's only 6,000, and then you pay the 6,000. If you don't pay the 6,000, I can walk off the job. And that's so. But that must be by notice in writing before I can walk off. That means that you're going to have adjudication dispute. We're going to have construction disputes, because in that situation, I'm saying it's 10k, you're saying it's 6k, so that leaves us with a dispute. And any dispute relating to payment under a construction contract can be referred to this new process, the new process called construction adjudication. It's brand new, it's going to be the subject of a lot of litigation, and it is something that's been talked about for 3 or 4 years, and we will be reporting at conferences like this about it for the next 3 or 4 years while it settles in. A party to a construction contract has a right to refer to adjudication the dispute. They serve a notice of intention to refer the payment dispute to adjudication. Then, within 5 days after that notice, they decide on who is going to be the adjudicator. If they can't agree on the adjudicator within 5 days, then the party who's referred the dispute to adjudication must ask for an adjudicator to be appointed. Now, the adjudicator who will be appointed, there are 30 of us. Joe Behan here is one of them. I'm another one of them. And there are 30 people in Ireland who will be appointed to adjudicate on that particular dispute in default. Can you see that still? So the party by whom the notice was served refers it within 7 days beginning on the day on which the appointment is made. So we've got the adjudicator appointed by agreement or by the ministerial panel. Then you've got 7 days in which to refer the dispute to adjudicator, and then at the same time provide a copy of the referral and all accompanying documents. Now, what I expect is going to happen then is some people will use lawyers, some people will not use lawyers, some lawyers will do a good job, some lawyers won't do a good job, some people will do a good job on their own, some people won't do a good job on their own. But the reality is that it's a very tight framework, and you've one shot on this to get paid quickly. The adjudicator then, we have to make a decision within 28 days, very, very tight. It can be extended up to 28 days with the consent of the claiming party, or it can be extended, but we must act with expedition, is basically. So this is a very quick, very summary. I don't know if those of you who are not lawyers know what I mean by summary. It's fast. You don't go into a lot of detail. You make the decision. You move on. But we must give a reasoned decision because of the Irish Constitution. That's not necessarily required in England, but it is the custom. The adjudicator must act impartially in the conduct of the adjudication, comply with the code of practice when it's published, take the initiative in ascertaining the facts and the law, deal at the same time with several payment disputes. So you can have a number of disputes before you at the same time, which may be helpful if there's a few, people are ironing out the problems, and then suddenly on the third payment date you realise, hey, this money isn't coming through. Well, you can put them all into the same adjudication. What's interesting is that we are entitled by statute to take the initiative, so we will be carrying out an investigation, if you like, more so than your usual flip-flop of the adversarial process that we're used to in arbitrations. And I'm close to the end here now, Joe. The decision of the adjudicator is binding until the payment of the dispute is finally settled by the parties. So, in other words, this payment is made, and up until now, the situation arose where you weren't being paid, you couldn't walk off the job, and you didn't get paid until the arbitration took place. That was the bind you were in. Now the situation is that there will be payment. There will be payment made along the way, and then when we come to the final account, either there's only a residue to be sorted out. If there is a residue to be sorted out, that can go to mediation, something like Joe. It can go to conciliation. It can go to arbitration, whatever is the provision in the agreement. If there's no written agreement, the chances are it's going to go to court. And so, in other words, these adjudication decisions must be complied with. They're binding in that sense, but they are not final and binding because the issues will remain to be opened in the arbitration and the conciliation that follows on the final account or before. It can be then enforced, the adjudicator's decision can be enforced in court, and we're awaiting the court rules that will allow for this way of going in and getting an order for the payment in the event of non-compliance with the order. That has resulted in a lot of litigation in England. We're expecting the same here, and the basis of the litigation has primarily been people challenging the jurisdiction of the arbitrator, saying that the arbitrator made an award outside of the job of work that she or he had been given to do, or that it was inappropriate, that the type of claim was outside of the definition of a construction contract. Those kind of challenges, or challenges that the adjudicator acted with bias or something like this. So all plenty of grounds for challenge have emerged in England over the past 10 years or so. And again, this self-help remedy is available, that you're entitled on notice to suspend work. And that is something that I'm sure a lot of people providing work will find very useful, because as we know, very often the clients would come to you and say, well, I walked off the job, and you're thinking, perhaps you shouldn't have, but I had to. So that's going to leave a possibility there that there's the protection of the statute, provided again they comply with that it's in writing and the proper period and so on. So what next? Well, we're waiting for the code of practice. I don't think there'll be any surprises in it. We're waiting. It sets out procedures to a great extent. We're waiting for the rules of court. I'd imagine that that'll be done by way of motion on notice. That's the word, I understand. And so it should go into the Monday list, or perhaps there might be a specific list allocated to it. And then it'll commence on the 25th of July. And if I'm invited back next year, I'll tell you what has happened in the meantime.